Hirsch. I'm the founder of the Hemlock Society of San Diego. That was 34 years ago when I was very young. And the Hemlock Society of San Diego at that time was a chapter of the National Hemlock Society, founded in 1980 by Derek Humphrey, who's still around, but the National Hemlock Society is not. So I think we're the last vestige of the National Hemlock Society, and alive and very well. We have meetings every month. They're all free. They're open to the public. You're always welcome to look at our website and find out what's next on our agenda. Our mission is to explain to people what their choices are at the end of life and all end of life issues, like today's issue on conservatorship, which is very important to many people who wind up in the clutches, if I may say so, of a conservator. And what we're going to talk about today is what conservatorship is about and how to avoid the evils while still keeping, hopefully, the good parts. We have a very excellent panel today of 3 people. Linda Kinkade, who is the founder of CEDAR, which is the Coalition for Elders and Dependent Adult Rights. I probably got that wrong, Linda, correct me. Nancy Spector, who's been an estate planning attorney in San Diego for 30 years. She is my attorney, so I hope she keeps me out of the clutches of the conservatorship. And finally, Thaddeus Pope, whom most of you know in the Right to Die movement, who's coming from St. Paul to be with us today. He's a health law professor at Mitchell Hamline Law School in St. Paul. My colleague, Pat Fisher, is joining me in this, and she has become very knowledgeable. Pat used to be the executive assistant of the Hemlock Society of San Diego, which Pam is now doing. And in the meantime, she has acquainted herself with the intricacies of conservatorship and knows more about it than anybody I know. So she's going to start out with some slides and a little introduction to conservatorship, and then we'll go right to our speakers. So Pat, if you are ready, we can start.
I want to tell you about a case where a valid advanced healthcare directive existed, but a man preparing to die on his own terms received unwanted medical care against his wishes and against his directive. Conservatorship enabled this revocation of an advanced healthcare directive. The questions this case bring up are you free to self-neglect yourself in order to end your life? If you lose capacity, are you obligated to accept unwanted medical treatment? The following case happened in Humboldt County, California in 2015. Mr. Magney named his wife as his agent and his sister as an alternate. Mr. Magney had been ill for some time with multiple serious health issues. While he was hospitalized under palliative care, Adult Protective Services, also known as APS, got involved because of a complaint alleging caretaker abuse or neglect by his agent, Mrs. Magney. This prompted Humboldt APS to file and receive an emergency temporary conservatorship of Mr. Magney, revoking his advanced healthcare directive. Unwanted medical procedures and drugs followed, possibly extending his dying process. Mrs. Magney had both the stamina and the money to hire an attorney to fight this. Ultimately, the system worked because Mr. Magney's wife was able to hire an attorney. APS was not able to obtain permanent conservatorship, although Mr. Magney was put under temporary emergency conservatorship twice. Mrs. Magney, after 3 or 4 years of legal squabbling and expense, obtained a $1 million settlement from Humboldt County. Mr. Magney died the same year that all this happened, but he did not live long enough to see the settlement. So now I'd like to share my screen and tell you a little bit about the terminology and classifications of conservatorships. California reserves the term guardianship for minors, but to make things a little more complicated than they already are, other states, Florida, for instance, use the term guardianship for adult conservatorships. Conservatorship guardianship means that a judge appoints someone to make decisions for you
It's not a
because
movie
you are
yet.
deemed to be incapacitated.
What?
For example, you could be in a coma from a car accident or suffering from dementia. The conservatee is the person deemed incapacitated and for whom decisions are being made. The conservator is the person with legal authority and responsibility to make decisions for you. Conservators can be and often are family members, but there are also professional conservators and, as a last resort, public guardians who work for the county. A conservator can control every aspect of your life, from selling or reverse mortgaging your home to petty things such as preventing you from taking books out of the library. Conservatorship involves rights being transferred from the conservatee, that's you, to the conservator. Conservatorship is intended to be a beneficent action, and hopefully it usually is, but there have been a constant stream of exposés followed by investigations, report writing, and additional laws, but the process seems to continually repeat and abuses continue to be reported. Each county runs its own conservatorship program, so rules may be slightly different from county to county. There are three main types of conservatorships. Two operate under probate codes. A general conservatorship is for adults and would include dementia patients and is the type you will hear most about today. Limited conservatorships are for people with developmental disabilities. Conservatorships can be of the person, which means the conservator is responsible for making decisions regarding your food, clothing, shelter, and perhaps medical decisions. They can be of the estate, which means the conservator is responsible for all of your financial decisions. The third type are LPS conservatorships, which apply to people gravely disabled. This would include the seriously mentally ill or persons impaired by chronic alcoholism. In San Diego, they operate under the welfare and institution codes, not the probate codes. This concludes our introduction. We'll send you back to Faye now to introduce Linda.
Thank you, Pat. That was a very interesting background. A lot to absorb, actually, if you're not familiar with this issue. So it is my great pleasure to introduce Linda Kinkade, who is the co-founder of CEDAR, which is the Coalition for Elder and Dependent Adult Rights. One of the few advocacy groups, I think, for people who are conserved. They conducted the first national study of elder abuse prevalence across all populations. Hope you'll tell us about that, Linda. And that data will inform public policy, they hope, for the coming decades. They presented at the 2015 Alzheimer's Association International Conference in Washington, talked about elder abuse as an emerging public health concern and elder mistreatment, identifying knowledge gaps among caregivers and social services agencies. So that could be all of us at some point. She's been an active advocate for elder rights since 2010, when her mother was a victim of horrific abuse. She co-founded CEDAR and they conducted, the study that I mentioned. So Linda, you have 15 minutes to tell us all you know, which will never work, but then you can answer questions. And so just tell us the high points and Pam will start timing. Linda Kinkade, you're on.
Thank you. I'm going to share my screen so you can see my slides. And I'm going to start the slideshow. Start. There we go. And I think I had better minimize the list of people over here. So if I get in danger of running over, feel free to verbally let me know I'm going too long because I can't see you anymore. The single most important concept that I want people to take away from today's presentation is that a conservator uses the conservatee's assets to litigate against the conservatee. It means if you're under conservatorship, they use your money to hire an attorney and litigate against you and potentially against your family. Think of any other service provider you might have, car mechanic, roofing contractor, dentist. It would be absurd to suggest those service providers could use your assets to litigate against you, but that's exactly what happens in conservatorship. As I've been introduced, Linda Kinkade, Master of Public Health from UC Berkeley, 25-year career in high tech, and now a full-time advocate for conservatees' rights. This is a quote that comes frequently from Claude Pepper. It's one of the, and he was quite a peppery fellow. He had a lot of great quotes. But we need to look at this idea of conservatorship versus felony conviction. A person accused of a crime can hire an attorney, any attorney they want and can afford. A person accused of a crime has many due process protections. And a convicted felon has a release date when he gets out of prison. A conservatee cannot hire an attorney of choice. Conservatorship proceedings often disregard due process, and conservatorship is almost always a life sentence. I want to read this second sentence here to you because it's really important. We terminate this fundamental and basic right with all the procedural rigor of processing a traffic ticket. Anyone can petition for a conservatorship over anyone else. Over 90% of petitions are granted. Our California probate code requires, quote, clear and convincing evidence to impose a conservatorship, but many conservatorship hearings last just a few minutes. There's often no testimony, no evidence. And in a lot of cases, the proposed conservatee isn't even allowed to attend the hearing. And once the judge signs that conservatorship order, the conservator controls everything. And I think this group is probably the most interested in the estate plan and the advanced directive. And so I've got some things highlighted in red as we go through to emphasize that aspect. The conservatee pays. If you're the conservatee, that's you, your bank account. You pay the conservator, the conservator's attorney, the court-appointed attorney, on and on and on. It gets very expensive, and they can bring in endless witnesses. They can go for all sorts of psych evaluations, medical evaluations. You get into dueling experts, giving different opinions, hearing after hearing after hearing. And it's not unusual for the entire estate to be depleted. And in fact, it's very lucrative for the attorneys. And conflict equals billable hours. This is important. We often see court-appointed attorneys doing everything possible to incite and increase conflict because it equals billable hours for everybody. Not for the conservatee, of course, but for all of the attorneys. We sort of jokingly refer to the guys in suits lined up at the table in the courtroom because they mostly are guys and they're getting paid very well. Absolutely the best way to generate billable hours is to isolate the conservatee from family, because families will fight down to their last penny trying to get access to a loved one who is isolated. And every court hearing means more billable hours, frequently thousands to tens of thousands of dollars per hearing. Roberta's case is a great example of lack of due process. Her conservatorship hearing lasted only 3 minutes. Her $2.3 million estate was depleted by the conservatorship. Margarita's case is another example of lack of due process. Ex parte means a secret hearing without notice to anyone. She was conserved without notice to herself or to her daughter, her only child, who was living with her. And you can see down here in red, the court used substituted judgment to create a new estate plan that excluded Margarita's daughter from inheriting from the $1.5 million estate. Eleanor's case, she got conserved 6 weeks after she remarried, after she was widowed. This one is kind of our classic case of churning the estate to generate billable hours. The conservator spent $50,000 of Eleanor's money to annul Eleanor's marriage. The conservator spent $60,000 of Eleanor's money to oppose a petition for Eleanor to be allowed visitors. The conservator spent Eleanor's funds to hire his own criminal defense attorney. Carol in San Bernardino is a little bit different case, but I think this one might really speak to the people who are interested in end-of-life options. Carol was taken from her home by her 2 tax preparers and her step-granddaughter. When this happened, she had advanced Alzheimer's disease. The kidnappers testified that Carol did not remember that she had a daughter. Carol believed she didn't have any money at that point in time. Yet they took her to an attorney who executed an estate plan, a new estate plan, voiding her existing estate plan. And there was a new advance directive nominating the step-granddaughter as conservator. And based on those new documents, the court appointed the step-granddaughter as conservator over the person and the $1 million estate. Well, that's all pretty gloomy. Let's look at possible solutions or things that might help. You know, in Carol's case, I have to think that if Carol had been a bit less secretive and had chatted more about her wishes, things might have gone differently. All 3 of the kidnappers testified that they believed Carol did not have any type of estate plan or any advanced planning documents. And if Carol had just chatted about she had a will naming her only child as her sole beneficiary, or that she had joint bank accounts with her daughter, or that she had nominated her daughter to be her agent for healthcare or to be her conservator if need should be. If she had chatted about those things, I have to think the kidnappers might not have seen Carol as an opportunity for profit. But in most of the cases that come to us, and I will freely admit that we see the worst of the worst, people don't call us up to tell us that things were great. We hear about the things that went horribly bad. Most of those cases start as a result of family conflict. And the bulk of the costs are fees to attorneys who facilitate those disputes in the courtroom, and entire estates are depleted and minimal resources go to the care of the conservatee. This is something that we're very happy about. This bill is now on the governor's desk waiting for his signature. Assembly Bill 1194 would allow a conservatee to hire an attorney of choice. That could get the court-appointed attorney out of the loop, unable to create that conflict. It would also require the attorney to be a zealous advocate for the client, actually representing the client's wishes and rights. We should note that the Trust and Estate section of the bar opposes attorney choice for conservatees. This is something that I'm very interested in, and my advocacy is really focusing on this option at the moment. There's the Uniform Guardianship and Protective Proceedings Act, was developed by the Uniform Law Commission, and they are very much in support of less restrictive options first. Before you take away someone's rights in a conservatorship, you would have to try other options first and explain to the court how those options didn't work. Several states have passed laws concerning supported decision-making as a less restrictive alternative to conservatorship. And disability rights groups in California are now pushing for California legislation to at least address the possibility of supported decision-making in California, and preferably to make it the default option for persons with disabilities. Those would be intellectual disabilities, developmental disabilities, or potentially disabilities that are acquired throughout life. But we also think that the same option can be used for seniors with cognitive impairments. And with that, I will stop sharing my screen and I'm open for questions.
Okay, we have 5 minutes for questions for Linda. I see there's some chat questions. Greg, you want to tell us what those are?
Who other than family members has standing to initiate conservator actions?
Anyone can file a petition to be conservator over anyone. I could decide that, you know, your coffee table back behind you looks a little bit messy. You're obviously having some cognitive impairments. I bet you've lost your car keys. I bet you've forgotten things recently. I could go to court and petition to be your conservator.
Watch out, Greg.
The answer is absolutely anyone.
You agree that is spoke? Yes.
But I put the site, the statute, the relevant is any interested person, right? So it lists a bunch of people in the statute, and then at the end it says any interested person. I don't now, Linda, you might have to explain why you're interested, right, in the care or protection of that person if you don't know them. But
churches petition, and when you dig around a bit, you find out that someone was going to make a donation, and then there's a chance they might change their will and change that donation, and all of a sudden you find a church initiating a petition. Sometimes care facilities will initiate petitions to be sure they get paid. Professional fiduciaries frequently file petitions. I haven't seen proof of it myself, but I hear stories that professional fiduciaries, professional conservators will get tips from people who work in assisted living facilities that, grandma in room 32 doesn't seem to have a lot of visitors. She may not have any family nearby. We think she has a lot of money, and golly, shouldn't she have a conservator to look out for her?
So the conservator idea is a very benign one. That is, people who can't take care of themselves could have someone take care of them. And that's, I think, has gotten very contaminated over the years, but it's a really very good thing to know that the court can appoint somebody to take care of you when you lose your marbles or whatever. I'm very comforted by that, except not what I hear now. Greg, is there another chat question?
I think
My question is, if you have somebody named in your will as a first choice conservator, should you need one, is the court obligated in any way to give that person the first opportunity to be the conservator, or can it simply ignore that point that you've already listed, or that chosen conservator, in favor of somebody who's an interested party?
Right. What do you think, Linda?
The courts almost never honor those designated individuals. And again, I will freely disclose that we see the worst of the worst cases. There may be many cases where things worked out as the family intended. We see the ones that don't work out because those are the people who call us. No, courts have complete authority to revoke, replace any of the documents. They frequently do, at least in the cases I'm involved in. Every single case we've been involved in had an estate plan with advanced planning documents. Every case that we've investigated had that estate plan in place. And in every single case, those documents were either ignored, voided, disregarded, replaced in some way. We've come to the point where we don't see them as having much value at all, at least once you're in court.
Well, that's good.
what can I do to protect myself from anyone getting a conservatorship of me because of mental illness and addiction?
Yeah, the reality is if someone really wants conservatorship, they probably will get it. There is nothing you can do to prevent a conservatorship if someone is highly motivated and knows how to work the probate court system. If you're concerned about mental health issues, I've been talking to a group in San Francisco. Senior and Disability Action has a subgroup that is specifically interested in mental health issues and conservatorship. And you might want to contact them and see what they have available for you.
Okay, what's their name again?
Senior and Disability Action. They're in San Francisco, and they have a group that is specifically focused on mental health issues, and they have a web meeting every other Friday afternoon.
So our next speaker is Nancy Spector, who is certified specialist in estate planning, trust, and probate law, and she's been an estate planning attorney for over 30 years. It's very interesting to hear the discussion between her and Linda, because Linda's sort of saying that there is no way to protect yourself. And meanwhile, Nancy's been doing these documents for 30 years. So we'll see what she has to say here. She is the former co-chair of the probate and estate planning section of the San Diego County Bar Association and former board member of the Alzheimer's Association. Alzheimer's, very serious issue here, and a frequent speaker on estate planning and plan giving. Nancy will speak about the importance of having the right estate planning documents in place. So from Nancy Spector's point of view, there is hope here. Nancy, you're on.
There is hope. I have total respect for what Linda does in protecting people's rights, but I totally disagree with her about a lot of the issues that she raised. At least I'm not seeing it in San Diego County, and I can't speak for any other county. What Linda was saying were all the negative aspects of it. where attorneys were ripping off the conservatees. There were kidnappers. There was all kinds of conflict. There's no due process. There's no notice to the conservatee. And the courts don't look at the nominations of conservators that are in the documents. And if somebody wants a conservatorship, they're going to get it. That has not been my experience with the attorneys, I'm sorry, with the judges in San Diego County. So I have to respect what Linda does, but I have to tell you, for the general public, they need to know what they can do. So I always say it's like the game of keep away. You try to keep away from I always say in estate planning, keep away from the IRS and keep away from the court, because that's what's going to cost you a lot of money and it's going to be a lot of time. So I want to explain what we can do the best we can to avoid the situation that Linda's talking about, which, you know, everybody wants to avoid, I believe. So let's move on with that. So we're planning for incapacity when and if that ever happens. It's an integral part of an estate plan. I deal with that when I give talks and I talk to people about what are they concerned about. They're more concerned usually about who's going to get my money, what about the taxes, all that's happening after death. And I say, yeah, but what about if you're incapacitated, then what? My license plate reads, plan ahead. And I believe in that. I believe that people need to plan ahead, and while you have capacity, and there are many legal ways to prepare for incapacity. And one of the major ones Linda did mention was to talk to your family about it or your loved ones so that they know your intent. If and when you become incapacitated, as far as your health care, as far as your financial situation, who's going to take care of what and all that. So while you have capacity, there are numerous legal ways that you can prepare for any incapacity. Many people have living trusts, commonly known as a revocable living trust. Some people put assets in joint tenancy, which may and may not be the best idea. You can plan by having things in community properties so your so-called well spouse can take care of things. Have an advanced healthcare directive, have a power of attorney for financial matters. And the last resort, in my opinion, is to go for a conservatorship of the person or the estate. The only one that I think is absolutely necessary is the one that was mentioned in the slide about the ones for disabled children. Disabled people, I should say, a limited conservatorship, almost 90% of the person rather than the estate, because the parents realize that this child who has been disabled now needs to have a conservatorship. So that's a different kind of conservatorship, but that's not our focus today. So communicate with if you don't get any other message today, communicate with your family what your intent is. And remember, in California, you're presumed to have capacity. Somebody has to prove that you don't have capacity. And in the courts in San Diego, there's a big burden there. And the judges will give you the right to speak for yourself or hire an attorney or whatever. So how can you avoid the conservatorship? And Fabe raised an interesting point the other day, where sometimes I have clients who are, you might say, in the gray area, and they're overwhelmed with preparing to file taxes or to pay bills. And sometimes it can be as simple as hiring a bookkeeper. And I often suggest that to the clients, like get somebody to help you to organize your mail, to pay the bills or whatever it is, so that you feel better about it. You know, they get, you might say, befuddled or totally confused at that stage of life, but they really haven't totally lost it. So it might be simple like that. If you have a trust, you should provide for the successor trustee and a way for this incapacity criteria to come about. So the usual old way of doing it is to say, okay, 2 doctors have to say you're incapacitated. Sometimes it has a doctor and your family member to say that. My experience has been, because I have wonderful clients on the whole and they listen to me, how about that? Like Faye. But my experience has been many of my clients actually resign. they get to the point where they say, you know what? I don't think I should be making medical decisions or particularly financial decisions. And they resign in favor of their wife, in favor of their children, in favor of a professional fiduciary. So that sort of makes it simple. As far as the trustee, who should act as successor trustee? And this question came up about a professional. I would say that most people name family members as successor trustee, but that might not be the best answer. It might be, maybe your children don't get along. Maybe the old way of doing it was to have your oldest son, how about that, traditionally, be the conservator. Be the successor trustee. Well, now that may not be the answer. What if your kids don't get along? Maybe it shouldn't be any one of your kids. Maybe your brother is the best person, but he could be your age. So then what? You could have a niece or a nephew or a friend. And sometimes people have no one to name. Their children are not responsible. There's no one in the family, or they don't have children. So they have a professional fiduciary or a corporate fiduciary. And this person acts as oftentimes the successor trustee, the agent under the power of attorney, not necessarily the healthcare one. Usually they have a friend or a family member do that part. So I think that is going to talk more about what is competency and the due process in Competence Determination Act under the probate code. So I'm going to defer to him. Looking at the power of attorney, you have the document. It says you are the principal, that's what they call it, the principal, and you name an agent, okay? So your agent is sometimes called an attorney in fact. The regular uses for this power of attorney may be to fund your trust. Maybe you're in the middle of a divorce at the time, so they handle that. Maybe it's because you're inheriting money, or to make gifts to other people on your behalf. Maybe there are new changes in the law. And especially I tell my clients, for those assets that are not actually in the trust, which would be retirement accounts, pensions, Social Security, insurance. So the management of those assets, if you become incapacitated, are what the agent under a power of attorney handles. There are two kinds of powers of attorney in financial matters. One is a springing one. One is a presently effective one. The springing one springs into action when you become incapacitated. And oftentimes it's based on, again, two doctors who say you are incapacitated, but it could be some other criteria. I have gotten away from using springing ones because it's hard to get doctors to say, okay, John is, or Mary is not capacitated. So a lot of times, unless they're young clients, I make them presently effective. And I say to my clients, you better trust these people because they're going to handle your manage your assets, but also don't give them the document and tell them where it is in case it's needed. The one piece of advice I would give the audience is that the banks like their own forms. So if oftentimes a client will come to me and say, oh, such and such bank won't let my daughter Mary be on the account. Well, the account's in a trust. The account is actually held in the trust. Well, that's why they can't put Mary on as an agent under the power of attorney, because the only trustee is the mother or the father or whoever it is. So the bank will, so what I tell them, go open up an account outside the trust in your own name and put whoever it is as the agent, whoever you trust, so they can write checks if you have to go to the hospital or whatever. But it can't be in the trust because you're the only trustee. But a lot of my clients really like that. But they also say, oh, you mean joint tenancy? And I say, no, joint tenancy means that person's going to get it when you die, whatever's in the account. And I've had people have 200, 300,000 in a joint account, and they never meant for that one kid to get that much money more than, let's say, the other children. So a power of attorney has to be notarized or witnessed by two people, but it's almost always notarized because a lot of them are recorded when it deals with property. There are court proceedings dealing with the power of attorney to make sure that agent is doing his or her job. And so it could be about an accounting, it could be abuse, it could be whether the power of attorney is effective now or whatever. Remember, the power of attorney dies when the person dies. Okay. So it doesn't, a lot of people try to use it after somebody dies, their mother, their father, whoever it is. And I said, no, you can't. It's done. Now, that's different than the Advanced Healthcare Directive, where there are certain duties that the agent can use after somebody dies. So what is an Advanced Healthcare Directive? It's saying, if I become incapacitated, I want this to be done, and I want these people to make the medical decisions for me. So you also should communicate with your family members what you want, and with your doctors. And I always give an extra copy of the power of attorney, I'm sorry, the Advanced Healthcare Directive, so that they can hand it to the doctor and it can go in your medical records. So again, you name an agent, you should always have an alternate agent. And who should be your agent? It's not necessarily the same person as your financial agent or your successor trustee. Sometimes you have a child who's great at finances, but would be a terrible decision maker when it comes to medical. And some people name an agent who's great on the healthcare, medical, but would be terrible for the financial. So think about it before you fill out the form. There are all kinds of forms. There you can get them at a hospital. They always ask you, when you go to the hospital, they always say, do you have an Advanced Healthcare Directive? Well, because they get money from the federal government, the hospital does. They don't have to have one on record, but they have to ask you, from my understanding. So I do my own forms, give it to the doctors. I'm sorry, give it to the clients, and they fill it out. I notarize it, whatever. You can get it from the County Medical Society, I'm sorry. And you can get it online. So it's, again, you need witnesses or a notary. One of the witnesses cannot be related to you. They don't want beneficiaries being one of the witnesses. It's often effective on the determination of your incapacity, which is an issue itself. It allows for access to medical records. It allows maybe for the person to say, this is what I want for prolonging my life, not prolonging my life, nutrition, hydration, funeral arrangements, cremation, visitation. Clients ask me, well, why does it say visitation? I said, well, I've had a situation where somebody is the healthcare agent, and they have a crazy brother or sister who wants to visit mom in the nursing home or whatever, and cannot, and they prevent it by using this document. An agent, like I mentioned, has duties after death. It could be dealing with the autopsy, cremation, organ donations, those kind of issues where they're buried. And, those are the kind of issues that really can be very disruptive, very upsetting to family members. You can also have, of course, a DNR, do not resuscitate form, so that if a family member or your caregiver calls 911, guess what? They're going to try to resuscitate you. So you have to be careful about that. There's a pulsed form. That's a pink form that you get from the doctor, and you should always have these forms available. If you have an old Advanced Healthcare Directive, you should look at the date. Before 1992, it expired in 7 years. Now there's no expiration. If you have none, the doctors may go to your closest next of kin, and that might not be who you want to make decisions, especially if you're in a relationship and you are estranged from your family members. Maybe you want your partner to make those decisions for you. So you better have the documents in place. I also want to mention something that a lot of people don't know is that if you're married or in a domestic partnership, if somebody is incapacitated and then you have a well spouse or a well partner, you might say, that person can make decisions for you under what we call the one transition action, which means that I've used it to sell a house, let's say, because let's say it's in joint tenancy, you need both signatures, or it could be getting into an IRA and they didn't have a power of attorney. So the so-called well spouse can go to court, have it simplified, and not have a full conservatorship. So I think that's very important. So getting back to the call for action today, plan ahead. Have your estate planning documents up to date. If you did it 15 years ago, you better look at them. Look at your beneficiary designations as well. Tell your loved ones where the documents are located. That seems like a simple thing. Not. Half the time, the clients have no clue where their parents put their documents. Be organized, and you will feel better, and certainly your family will feel better. So good luck. That's it.
that's our motto for the Hemlock Society too. So thank you, Nancy, for reiterating that. And I know you raised a lot of questions, Greg. What's on tap? We have 5 minutes to answer some of these hands.
I hope I can.
I'm sure you can.
I'm confused on the POA for financial. You said that if your accounts are in a trust, then your POA, your agent can't be paying bills and stuff. I mean, I don't totally understand that part.
That's a great question. And people ask me that all the time. Most people have at least one bank account outside the trust where their Social Security comes in or their pension comes in. And that you can definitely have somebody as an agent on that account. And like I said, it's better if you get the bank, Wells Fargo, Bank of America, or whatever, to use their form, because then they don't send it to their legal department and all that stuff. The power of attorney is only good for what's not in the trust. I know that sounds crazy, but the trustee, the successor trustee, is the one that would be handling what's in the trust if you become incapacitated.
Right.
Most people, Virginia, most people have retirement accounts or have some kind of benefits that are not in your trust. And that's what the power of attorney person, the agent, handles in
Okay.
that, with that hat.
Right.
Sometimes I want to answer that because oftentimes it is the same person, whether it be a family member or a professional fiduciary. It often is the same person, but wearing different hats.
Yes.
Morgan had a question about how to get an advanced healthcare directive.
Yeah, like, is there a group that I could go to get the form, or like my psychiatrist, or how do I go about planning that?
Well, first of all, I think it's very important that you have a California form for both the healthcare and the power of attorney. When clients of mine who moved lately to Idaho or to the state of Washington or something, I tell them, get one that's for that state particularly. See an attorney for that state so that everything complies with that. My documents are valid anywhere, but it's good to have the local, the state ones. You can get, Morgan, I mentioned this, you can get it online, a California healthcare directive. You can go to a hospital. You can get it from the medical society. It's pretty easy to get one.
Pam, we have them on our website, don't we?
We do.
Okay, well, there you are.
These form, and our form also includes the dementia directive, which Thaddeus may talk about later, I don't know, but that's a very important consideration.
Are EMTs or ERs honoring advanced directives, or are they taking all measures to save you?
Do you have capacity? You can tell them yes or no. If you don't have capacity, then they are supposed to follow your advanced healthcare directive, period. But you got to have it. You got to give it to them, or somebody does.
It doesn't count if it's tattooed on your chest either.
It doesn't help if it's in a closet in a file drawer.
Someone has said that something about a quality of life advanced directive, which I've never heard of before. What is that?
It's interesting. There are different forms that you can get, especially when if you're Jewish or Catholic or whatever, you can write what you wish, the wishes that you want, basically. And I think it's a great idea. It's what you want your family to know about your wishes and what you want them to remember about you oftentimes. But I think it's really important that people actually write down what they want, as well as talk to the family members and keep it right with your documents.
But on that point a minute ago about the EMTs and ambulance people, they are not allowed to follow an advanced directive because an advanced directive needs to be read and interpreted and then translated into medical orders, right? The scope of practice for that level of healthcare licensee is narrow, right? So they follow orders, and if an advanced directive has not yet been translated into orders, they will transport you to the hospital. So they need a post. They can follow a post because a post is a set of medical orders, but they are not allowed to follow an advanced directive. So you will be transported. And
And
and then you'll be at the ED. And it's only sometime later after you're already at the hospital that somebody will have the opportunity and time to read your advance directive and figure out what orders to write for you based on your advance directive.
Which comes back to the issue of communication. So if you're living with your daughter or you have a caregiver, you have to tell them, if this happens, don't call 911, basically.
I wanted to ask a question, and I apologize if this was touched on. I know I meet a lot of people who are single and they live alone and they don't have anybody to indicate for an emergency, to someone to be there. They don't know who to put down, and I would love to get some feedback about that.
Very good question.
It is a good question, and I also face that. First of all, to get to the first point you made about the big envelope, I give my clients something called a document locator that they can fill out, who's their doctor, who's their attorney, who's the closest relative, where are the accounts, all those kind of things, the accountant, whatever. So it gets people organized, which I think is really a good idea. The second part of your question about single people living alone, maybe they have to reach out or notify a neighbor or have a phone call of somebody who can be contacted if something happens to that person. Or I have one guy who has a niece back in New York, and on his refrigerator, he put, if something happens to me, call Heidi in New York. Everybody has somebody, in my opinion, that can be contacted. And there are a lot of people who are alone in this world, a lot. And that's why many of my clients have a professional fiduciary involved. And I should say they're licensed, they have continuing education, and my experience, I can't speak for anybody else, my experience is the professional fiduciaries whom I work with are very good. Now you can say no, you can argue with me, but I won't refer anybody whom I don't trust, and I work with them every day.
That's very comforting, Nancy. We have time now. Barry, can you hold it till we hear from Thaddeus Pope, our last speaker, and then we'll have half an hour or more if you'd like to stay for questions that may not have been answered. Thaddeus Mason Pope, PhD, JD, is a health law professor and bioethicist at Mitchell Hamline School of Law in St. Paul. He serves in a wide range of consulting capacities. He has an amazing website, which many of us in the end of life field know very thoroughly. He's ranked among the top 20 most cited health law scholars in the United States. He has over 225 publications in leading medical journals, bioethics journals, and law reviews. He co-authors the definitive treatise, The Right to Die, the Law of End of Life Decision-Making, and he runs the Medical Futility blog with over 4 million viewers. And without further ado, Thaddeus Pope. You're muted.
Thanks for having me. Let me just
Thanks for coming for St. Paul.
Okay, I'm going to take an approach a lot like Nancy, which is sort of a proactive, preventative approach. So I call this 8 ways to avoid conservatorship. So thanks for having me. I know I've spoken to the Hemlock Society of San Diego before. It's always a pleasure. Conservatorship, I think, might be thought of as like a circus net, right? It's there if you need it, but the performers, don't want to have to use it, right? And in fact, conservatorship, as we heard, is a last resort. Judges really must prefer any less restrictive alternatives. This is built into the California probate code. So when you're talking about the petitioner, the person who's filing for the conservatorship, they need in their papers to show that they need to explain why alternatives to conservatorship aren't available, why those won't work. And another section of the probate code tells judges that they can't appoint a conservatorship right? No conservatorship shall be granted unless the court makes an express finding that conservatorship is the least restrictive alternative needed for the protection of the conservatee. So we heard that there's conservatorship of the person, conservatorship of the estate. I'm going to focus on conservatorship of the person and focus on healthcare decisions. And so what is a less restrictive alternative to conservatorship for healthcare, right? As we heard from Nancy, it's an advanced healthcare directive is a key tool, a key alternative. Now, of course, if you still have capacity, then you'll just make your own healthcare decisions for yourself. But most of us at some point are likely to lose decision-making capacity. And an advanced directive is a key tool by which we can make sure that our voices, our wishes, our preferences are heard, even when we're not able to speak on our own behalf. So here's my roadmap, just two parts coming up. Part one is obviously the first thing you have to do is actually write your advance directive. We're not very good at that in America. This is a study in health affairs, the largest study ever done. This study, it's a meta study. So it looked at 150 other studies involving 800,000 people. So it's a big sample size for a study. And they concluded that the advance directive completion rate in the United States is 37%, not very good. And this is a different study, a Pew study, where they broke it down by age. Even if you focus on people 75 and older, the advance directive completion rate is only 58%. So it's higher, but still not all that high. So the first step I'm going to talk about is just write your advance directive. But what I'm really going to focus on is part two, which is optimizing your advance directive, not just writing it, but writing it well. Okay, so the first step is write it, right? There's two parts to an advance directive. You can appoint an agent and you can record your wishes. Almost everybody thinks that appointing the agent is the more important part of an advance directive, right? Because this person, you're designated, this is the person who I want to speak for me when I can't speak for myself, because that person can respond dynamically to whatever future clinical situation arises. And we don't need a conservator because you already have at least as far as healthcare goes, because you already have somebody. You pick them yourself. Who should you pick? You should pick somebody who has all or at least most of these 6 traits. Somebody who knows you, somebody who cares about you, somebody who's willing to serve as your healthcare agent, somebody who's willing to honor your wishes, somebody who's able to serve, meaning they're going to actually have themselves be in good enough health and ideally actually live nearby and not be that niece in New York, and somebody who would be a good advocate. So first thing is appoint your agent and appoint a backup in case your primary agent isn't available. The other part of the advance directive, right, is where you record your wishes, right? We used to call this the living will. You can record treatment that you want, record treatment that you don't want. And there was a question a few minutes ago, right? Where can I do this? There are so many paper forms from so many different hospital systems, advocacy groups, and so forth, electronic forms, and lots of apps as well. Some of those are treatment focused. So you can go through therapy by therapy, CPR, dialysis, mechanical ventilation, artificial feeding, and so forth. Other advanced directive forms are more goal focused. So like 5 wishes. So it's not specific to therapies, but you would record these are the things that make my life worth living. These are the things that would make my life not worth living. The advantage of any type of advanced directive, right, is that the clinicians get to hear from you yourself, right? The best decision maker for you is you. The purpose of advanced directives is goal concordant care, right? We want to make sure that you get the treatment you want and you avoid the treatment that you don't want. So that's step one, right? Step one is appoint your agent and your alternate agent. And if you want to, record your values and preferences. So let's say you completed your advanced directive, okay? You're not done yet. You have to move to step 2. What's that? Well, you have to make it legal. Nancy referenced this, right? You're going to need to get it witnessed or get it notarized. Because of COVID-19, most states actually now allow remote witnessing and remote notarization. But unfortunately, the bill that would have done that in California did not pass. Let's say you get it witnessed or notarized, you're still not done. You got to move to step 3. You got to talk to your agent, right? You theoretically, you could just appoint them in your advance directive, get it witnessed or notarized, and never tell your agent that you in fact have appointed them. That's not a good idea, right? You want to make sure that they're available, make sure that they're able to do this, and make sure that they're willing to do it. And there are some good guides, because you're sort of asking them to do a job for you. What are their job duties, right? They need to understand what it is that they need to do. And there are some good guides like this one that help them understand what they're supposed to do as a healthcare agent. Still not done. Step 4, make it findable. This is actually where things really, the ball gets dropped. A lot of advanced directives are completed, but they're not found. And I know Nancy just referenced the fact that a lot of her clients, the family doesn't know where the documents are. So completing an advanced directive is not the same thing as having an advanced directive. More precisely, it's not enough that you have an advanced directive. Your healthcare providers need to have it, and that doesn't happen. There's a study from HHS, 76% of physicians whose patients have advanced directives don't have them or know that they exist. So you need to make and distribute copies. So you're going to need to give one to your agent and to your alternate agent, and scan one into your electronic health record. And California does have an electronic advanced healthcare directive registry run by the Secretary of State. So you can have one loaded into this sort of, cloud-based registry, which again maximizes the chances that it will be found. Still not done. Step 5, make a video to supplement your advanced directive. Videos help resolve disputes over the validity or the meaning of advanced directives. So just give a quick example in terms of validity. There's a recent case in Southern California involving Sumner Redstone, who was the multi-billionaire majority shareholder of CBS Viacom. And he had completed an advanced directive naming his healthcare agent, his companion, Manuela Herzer. But then later, completed a new advanced directive naming a new and different agent. And when you complete a new advanced directive, that automatically revocates the old advanced directive. So effectively, by completing a new advanced directive, Manuela Herzer was fired as healthcare agent. She didn't want to be fired. So she argued that Redstone did not have decision-making capacity to complete the new advanced directive, so it's invalid. And the old advanced directive appointing her is still the valid operative advanced directive. Now this goes to court. Now Sumner Redstone at this point had a lot of cognitive problems. And this goes to LA Superior Court, and they bring in a lot of the world's best geriatric psychiatrists. But the court ultimately ruled that Sumner Redstone had capacity to complete that advanced directive. Why? Because of a video where he, in his own words, is explaining why he completed it. The judge could hear and see, okay, it sounds like he knows what he's talking about. This is what he wants. So sometimes it happens that somebody shows up claiming that the advanced directive is invalid because the patient lacked capacity to complete it. Videos help prove advanced directive validity. They also help prove the meaning of the advanced directive, right? What exactly did the patient want? Did she want that under these circumstances? It helps to hear the patient in her own voice explaining what she wants, in addition to just an advanced directive document. Let's say you've completed your advanced directive, you signed it, you had it witnessed or notarized, you've shared copies of it, and you made a video. What next? Well, I published a book just a few weeks ago called Voluntarily Stopping Eating and Drinking, which is largely focused on dementia directives. And when it comes to dementia, another thing that we recommended if you've already been diagnosed with dementia at the time you're completing the advanced directive, is to have a clinician assess your capacity and affirm. So you have a note from your clinician affirming that as of the date you're signing your advanced directive, you had capacity. Attorneys can also do this as well, although a clinician might be better. Still not done. Step 7, you need to review your advance directive. Generally, the recommendation is you review it at any of the 6 Ds. Whenever there's been a death of a family member or friend, if you've had a divorce, if you have a new diagnosis, if you've suffered a significant decline in your health, whenever you reach a new decade, or you had a change of domicile. Those are the traditional 6 Ds. You might add a 7th D, given the sorts of things Linda was talking about. Maybe we call this one desperado. So there are sometimes people who show up at the hospital or the long-term care facility. They're not your healthcare agent. Maybe they're a family member, but you knew that they might. You knew that they might have been a problem later on. So in your advance directive, you can not only identify who you want to speak for you. So you can identify your agent and your alternate agent, but you can also clarify who it is that you definitely don't want to speak for you. Like, I love my son dearly, but I don't want him to take any part, in my healthcare decision-making. And that can help if there's a later dispute. Still not done. Final step is a pulse, and this came up in the Q&A a minute ago, right? This supplements an advance directive. It doesn't replace it. Every adult in California should have an advance directive, but only a small subset of us are going to need a pulse. Who's that? Those who are expected to die in the next year, right? People with terminal illness, advanced chronic progressive illness, or frailty, right? A pulse is a little bit different than an advance directive. It's a transportable medical order set, which means it's immediately actionable. So as we discussed a minute ago, EMTs can honor it. It maximizes the chances that your wishes will be followed because it's a very simple form. It's a uniform form that's used across the whole state. And there's no need to read what sometimes is a 4, 5, 6, 7 page advance directive and figure out what it is that the patient wants and translate that into orders. The O in PULSE stands for orders. They are already orders. Anyway, it makes it easier for healthcare professionals to follow. So to wrap up, ideally, you will make your own healthcare decisions because you have capacity to do that. If you lose capacity, then ideally you've appointed an agent to make those decisions for you. And it's only when when you lack capacity and there's no available agent to speak on your behalf, it's only then that we should really need to get a conservator. But, right, things don't always work out as planned. Right, we all take the time to buckle our seatbelts and put on our helmets and things like that, but doesn't always work out. So ideally, advance directives could help avoid conservatorships in the first place, but they have value even if a conservator is appointed in 2 ways. First, this came up earlier in the Q&A, it helps control who gets appointed, right? So the probate code provides this, and almost every form advance directive has a section where you can say, if a conservator of my person needs to be appointed, I nominate my agent, right? So you can help tell the judge, this is who I want. And the judge is supposed to consider. The whole point of all of this is that we want to make sure that the person speaking for you is doing what you would have done for yourself to the extent possible. The other thing you could still do, the other reason advance directives still have value, even if there is a conservatorship, is it does control or constrain what exactly the conservator does. So the California Probate Code says the conservator shall make healthcare decisions in accordance with the conservator's healthcare instructions. So if you've said, these are therapies I definitely don't want, or these are therapies I do want, or these are my goals of care, the conservator should act consistent with that. Thank you.
Thank you, Thaddeus. So you have 5 minutes to ask Thaddeus questions, and after that, it's open field to ask any questions, electronic hand raising or chat.
I would like to make a couple comments, and I really appreciate what Thaddeus added to what I said. One is that I forgot to say that if somebody's in a skilled nursing home, they have to have an ombudsman or a patient advocate be one of the witnesses It can be a notarized or witnessed with another witness. Another thing is that whole case about the Sumner Redstone I found very interesting, and the video issue. Videos were very popular in estate planning a couple years ago. And then my litigator friends said, maybe it's not such a good idea because maybe they didn't look so good in the video. Or when it comes to court, they say, was that the only video you made? And they find out, well, there was one before it that they wiped out, they eliminated. And so this is what we produced. And so sometimes it backfires. That's all I'm saying. And when Thaddeus said that about a clinician verifying the healthcare directive, I have found that whenever it's a questionable issue in estate planning, I will have the client see a psychiatrist, hopefully a geriatric psychiatrist, to evaluate that person. Let's say they're eliminating all their children and giving everything to charity, okay? This is just an example. I think it's wonderful, but I'm saying that one of their kids could come back and say, mom didn't know what she was doing. So I have it as close to the signing date, have her meet with a psychiatrist, get a report. So it's not just related to an advanced healthcare directive. It could be all her documents, including her trust. And I have done that.
In the case of someone that goes to the hospital, they have a pulse that went with them to the hospital. But in a case where the person then needs to do some recovery in, say, a nurse skill in a rehab place, which is really like a nursing facility. How does that work in terms of maybe the information going with them? Because there are different doctors that that often are in the rehab places. I'm just wondering if there's ever kind of a confusion in that kind of scenario.
I mean, I didn't, obviously I only left 1 minute for the whole post, but
Sure.
One of the other benefits of Pulse that's almost always, there's an organization called CCCC, the Compassionate Care Coalition of California, and they sort of are in charge of educating and promoting Pulse in California, educating both family members as well as clinicians. Another key benefit of Pulse is it's portable, meaning it should follow you, right? So if you're at home, it would be on your refrigerator. If you go to the hospital, it would go to the hospital with you. Then if you go from the hospital to the rehab, it should follow you wherever you are. There are some challenges, right? Because there's issues of technically the person that signed it, right? So the person who wrote those orders may not have privileges at that hospital or at that rehab facility or at that SNF. And then therefore that place may want to rewrite it, right? So in other words, we'll write a new post because we don't want to be honoring, literally having our nurses follow orders from a doctor that's doesn't work here, right? But I don't know, I hope I answered. I mean, it should follow you, right? So the point is, if you took the time to do a post, that is binding and it should be honored. And in fact, increasingly, this wasn't the tradition, but increasingly in the last 2 or 3 years, there were a lot of lawsuits, including the Magney case, which we started this whole webinar with, where when people's wishes aren't honored, they sue. And not only are they suing more than they used to, they're winning. In a post, especially if the patient is the one that a surrogate can complete a post for a patient, but especially if the patient completed the post herself, those are thought to be clear and convincing evidence of her wishes, and therefore everybody should be following that.
That is, a lot of people are doing posts instead of advanced directives because they think it has the force of law more.
That's nobody thinks that's a good idea, because Pulse can't do things that an advanced direct. So the main thing is you can't appoint an agent, right? The Pulse is only about it's limited to specific therapies, and one of the key things we just talked about in this whole webinar is if, let's say, we think that the Pulse is no longer it needs to be updated because your clinical situation has materially changed. who is it that we're going to get to? If you lack capacity, who are we going to get to sign the new post, right? Because the doctors think the old post no longer speaks to your clinical situation. So that's a key. I mean, there's other reasons. That's a key reason why you'd still want an advanced directive, because the advanced directive would say, this is the person who can write my new post for me.
And some people who don't have, like Susan said before, don't have somebody to appoint as their durable power of attorney, prefer the post because they don't have anybody.
Well, but I guess I would never say it prefer the post. I'm trying to repeat this. This has been long discussed, right? Is that you could definitely, most of us probably have advanced directives, but most of us probably don't have a post on this call. But the reverse, nobody recommends the reverse. So I want to just say first, there's a whole lot of people who spend a lot of time thinking about post in the best, safest way from a patient safety perspective and so forth. Nobody recommends getting a post with no advanced directive. I get that if you literally, this question came up earlier, some people just, and Nancy was rather optimistic. She says, oh, you'll find somebody. But I get the challenge. There really are people who are sort of socially isolated. Their family, they've outlived their family. They don't really have any friends, right? That's what you're saying is, who do I put down as my agent? I really don't have anybody to put down.
Yeah.
Yeah, I don't have a solution for that. But we should be working on that.
So this is regard to the same thing, the post and the advanced directives. I have changed my advanced directives and I had to change my posts for different reasons. So one of the things I want to say is that I had an emergency now, and the ambulance came for me. They took my post and they just kept it, or I don't know what they did with it. I never got it back when I went to the hospital. So that's a problem that I don't know how that can be solved. It just get taken away. So I want to know, if I understand that there's a place where you can register both the advanced directives and the posts. What is that?
So there is a so there's a go to if you just type a California Advanced Directive Registry. I mean, you could Google that. So we call it a registry. Many states have registries. California is not one of the better ones, but the Secretary of State does run a registry. It's called a paper registry because you literally have to mail a copy in and then they'll scan it, as opposed to you scanning it yourself and loading a PDF or something. But you can. Well, I'm not sure if that's for. I think there's a separate post registry. I'm not, but so. It is a good idea to do that for the reason you just said, which is the paper copy might get lost. So clinicians are trained to think, oh, Eugenia's here. I wonder if she has an advanced directive. I wonder if she has a post. And they will, as long as they know who you are and they know your name, which they're going to figure out because they want to be able to bill somebody, then they will, they can query those databases and if it's there, they'll get it and they'll download it and print it out.
It's been wonderful to hear this discussion. I love how Linda and Nancy don't agree. I think that's perfect because it's certainly not a simple matter. And I can't wait to see the Britney Spears special tonight at 8 o'clock on CNN and watch the Guardians, that movie. And I definitely recommend She Cares a Lot as a horror movie of what can happen. And Pat, you've been very quiet, but thank you for everything that you've done to make this a success and everything you've taught me about it. And we can say good night and thank you very much all for coming. And thanks, Pam, for being the timekeeper. And thanks, Barry, for running this show.